retired senator, and I'm the executive director of both one of the organizations that's hosting this candidate forum. And this is our office in this building, and we want to welcome you to the building. Some housekeeping rules. First, we'll ask everybody to silence their cell phones, so we won't have any interruptions as we're moving forward. The restrooms are straight out the door, down the lane, all the lanes, when you hit the wall, make a right, and make a sharp left. Whatever happens first is the female line. You can take the elevator down, or you can take the stairway down, either one. That's what you fancy. Some of the groups that help us organize this candidate forum, judicial candidate forum, is Citizens for One Greater New Orleans. Raise your hand when you're in the room. Court Watch NOLA. The League of Women Voters of New Orleans. The National Council of Jewish Women. The Greater New Orleans Urban League. The Urban League of Greater New Orleans. The National Coalition of 100 Black Women. And Voice Like the Family, which is our group. Forum sponsors include the Lands and the North Coalition. We'd like to thank them for their contributions to helping us pull this thing off. Other participating organizations include the Family Justice Center, the Louisiana Center for Children's Rights, the Metropolitan Crime Commission, the Police and Justice Foundation, the Press Club of New Orleans, the Southern Poverty Law Center, and the Young Leadership Council. And so I will bring up Yvonne to kind of like do the rest of introductions, and you can get this show on the board.
Thank you. Good evening. I'm Yvonne Mitchell-Grubb, immediate past president of the National Coalition of 100 Black Women, Greater New Orleans chapter. And we welcome you to our judicial forum this evening. I have the honor to introduce our moderator for the Criminal District Court Forum. Mike Perlestein has worked as an investigative reporter at WWL TV since 2010. As a member of the Eyewitness Investigative Team, Mike has tackled a wide range of stories exposing government waste, corrupt officials, and miscarriages of justice in the court. Mike moved to New Orleans in 1986 to work as a staff writer at the Times-Picayune, where he immersed himself in the region's spicy politics, hard-edged crime news, and rich environment for investigative reporting. He wrote extensively about crime and punishment, earning many national and regional journalism awards. Mike was awarded the Pulitzer Prize for breaking news and public service as part of the newspaper team that covered Hurricane Katrina. As an educator, he has shared his frontline reporting experiences with hundreds of aspiring journalists, teaching at Southern University at New Orleans, Dillard, Tulane, and Loyola. Mike has a master's degree in journalism from the Medill School at Northwestern University and bachelor's degree from Reed College. In his spare time, he coaches soccer and basketball teams for his 3 children. Introducing to you, Mike Perlestein. And I just want to mention to you that tonight's forum is being broadcast on Facebook Live and YouTube.
Thank you very much for that warm and kind introduction. A note of appreciation for all of the nonprofit groups and community groups who are hosting this important judicial forum. I am going to invite now the 3 candidates for the Criminal District Court seat. So without further ado, we have Judge Paul Bonin, please. We'll take these in alphabetical order. Candidate Kevin Guillory. And candidate Dennis Moore. Okay, what we'll do as three gentlemen for this criminal court seat, which is a seat that was vacated with Frank Marulo's retirement, as we call that. We will, of course, have all candidates promise to be civil. This forum/debate will prove not to be nearly as spicy as some that we've seen in national politics, but hopefully we'll keep it lively. And we will start with letting each candidate give a brief introduction of their background, starting with Judge Paul Bonin.
Okay, thank you very much, Mike. Thank all of y'all for being here. I'm Judge Paul Bonin. I am currently serving on the Court of Appeal here in New Orleans. Our criminal justice system is in crisis. And when the criminal justice system is in crisis, the community is in crisis. And what I propose is that we need to look at the causes of these crises, which most of us know, that we're not at all satisfied with the reliability of, oh, I'm sorry, can y'all hear me? Did y'all hear me? I hope y'all can.
This is better than.
That we're not at all satisfied with the reliability of the outcomes at Tulane and Broad. Now, there's a lot of different reasons for that, but we cannot, any of us, be pleased with wrongful convictions for which our parish is the leading poster child in the United States of America. That's number one. Number two, we are over-incarcerating. We know this. We're over-incarcerating from the moment of arrest until people are dying in penitentiaries unnecessarily. Some of those people need to die. But we're in Louisiana. It's been identified that people, the problems with over-incarceration are putting people in jail for drug offenses unnecessarily, revoking probation unnecessarily, and restricting the opportunity for parole. A judge can work to address the problems of wrongful convictions and getting it right, getting it correct at the very beginning of the case by being caring and concerned. My feeling is this: all we need in a judge is a judge who is committed to two principles. The first, that every person is entitled to the respect that is demanded by their human dignity, and secondly, that the judge is to adhere at all times to the Bill of Rights and the Constitution of the United States. If we keep focused on respect for dignity and on the Bill of Rights, we're going to be able to restore confidence in our system of justice, and we can be, and my time is out, but hopefully we'll get to some of these points. Thank you.
Great. And I will ask the candidates to, number one, adhere to the high-tech system of timing over there. You see those signs. And speak into the microphone so everyone can hear you. Okay. Mr. Guillory.
Good evening, ladies and gentlemen. First of all, I want to thank you all of the people that have come out to attend and witness the forum. I want to thank all of the groups that have gotten together to put this forum on and give myself and my opponents in this race venue an opportunity to address you all. My name is Kevin Guillory. I'm number 77 on your ballot. I am currently an assistant district attorney, major offense trial attorney. I've been prosecuting homicides, aggravated rapes, and aggravated kidnappings since 2009. I also worked as a defense attorney for a little over 2 years, so I've been on both sides of the courtroom. I agree with Judge Bonin to the extent that I believe that there is a problem with our criminal justice system as it currently is. We have a system that is more focused on punishment rather than rehabilitation, on over-incarcerating rather than trying to help people that can be helped. I believe that the system needs to be reformed. I believe sentences need to be reformed. I believe that the way that the judges practice at Tulane and Broad needs to be reformed. We need to find a way that we can reserve incarceration for those that actually need to be incarcerated, the most violent offenders amongst us. However, there are a lot of people, first-time offenders, non-violent offenders, that we need to take advantage of the court services that are currently available, as well as implementing new services so that we can provide ways to rehabilitate those people and prevent them from coming back through the system. In my experience, the majority of people that have come through court have been repeat offenders. If we can break that cycle of recidivism, if we can lower the crime rate, and we can improve our city and the community. I look forward to answering your questions during this forum, and look forward to meeting many of you individually after the meeting. Thank you.
Dennis Moore.
Good evening, and first I thank everyone for allowing me to come here to speak tonight. My name is Dennis Moore. My number is 70. I come to the position I am in running for judge for one reason, is that I'm tired of us doing the same thing and saying the same thing and nothing changes. I have been a criminal defense attorney for 18 years, so I've been in the ground fighting the issues that we're talking about. Fighting a situation where the DA actually want to put everybody in jail. Even today, they want to put everybody in jail. It's nice to say that we want justice reform, but on every day when I go and fight for justice reform, I'm finding that the DA still wants to put people in jail using the multiple bill statute. They also want to put people in jail as a way to keep other people in jail. And I'll say it this way. Our system has been where we want to put people in jail and say we put them in jail and throw away the key. Everyone wants to say, hey, well, we can do better, but we don't do better. How do we do better? We need to reform the system. How do we reform the system? We need to modernize the system. It makes no sense that we have a court system where you cannot get online and look at the docket master system, the document system. I'm talking about the judge's document system. And once I have the opportunity to speak to you tonight, we'll go into it and you will know the reason why I believe I'm the best qualified for this position. Thank you.
All right, gentlemen, please have a seat and then pass the microphone around as you get individual questions. We have questions that have been submitted by the groups hosting, and I will interject some of my own questions. And we'll do it in a way that you wonder which is which, so I don't get blamed for maybe some of the more journalistic questions. But I'm going to start just by very quickly asking some line of questions. I'll fess up to these just for each candidate on your motivation for running. Starting with Judge Bonin, once again going in alphabetical order. You've been Judge of Traffic Court, currently Fourth Circuit Court of Appeal. Why the heck did you want to go to Tulane Broad Criminal Court?
Because that's where the trouble is, and that's where, the judges at criminal court are the first responders in our criminal justice system. And if we're going to do something about it, it can't be done only from the briefing booth, all right? It's got to be done on the ground, in the courtroom, and I think, with all of my years of having been a judge in traffic court, where I have to say, we did many innovative things with respect to victims. We did many innovative things with respect to community work instead of fining people and over-fining them and loading them down with court costs. Things that I'm very proud of. At the Court of Appeal, we have done in-depth work of looking at issues. I've taught. In fact, I'm very proud. There's at least 2 young women in the audience today who are students at Delgado in criminal justice who are being taught by one of my students from SUNO, Criminal Justice Graduate Program, at Hayward. And it's beautiful. I've been thinking about these problems. We have a moment in history right now where our state can do something about it. And I believe I have a personality and temperament that can actually make a difference in that court. So that's why I'm leaving a beautiful building and a wonderful job. If you, the public, say, it's okay with you for me to do it, because it needs to be done.
Okay, for Kevin Guillory, you're an assistant district attorney running for this seat at a time when much of the focus and attention is on Louisiana leading the nation in incarceration rate, on the racial fairness of the judicial system coming into question. You're coming from the prosecutor's side of the aisle. Wouldn't that seem perhaps against the grain of some of the current issues that are front and center in this race? Please address that.
I appreciate the question, Mr. Perlestein. Let me say this, ladies and gentlemen. My employment is as an assistant district attorney. My employment does not define myself nor my character. For 12 years, I've gone into that building, and whether I've represented people as a defense attorney, whether I've prosecuted them as an assistant district attorney, when I look across the courtroom or on my side of the courtroom, whichever side I was on, I saw people that looked like me. I saw people that were from my community. I saw people that grew up in neighborhoods that I've grown up in, that were familiar with, that played at the parks I played in, that went to the schools I went to. I saw people who I knew growing up. I saw people whose mothers, sisters, grandmothers, aunts that I've known. So the fact that I've worked the majority of my career as a prosecutor doesn't mean that I go into this, or I would be elected, I would be a prosecution friendly or a pro-prosecution judge. I can attest that I see about 2 rows full of attorneys that I practice against on a regular basis, and I've developed a wonderful reputation for being one of the most fair, one of the most impartial prosecutors at the district attorney's office. I have used my position within the district attorney's office to help to influence change, to influence deals, to make sure that fairness is achievable to all parties, regardless of what neighborhood you come from, what you look like, what school you went to, and what political connections your family may have. I have no shame in being a prosecutor, that I was a prosecutor, but I am not a prosecutor at heart. I am a person that is strictly focused on justice and fairness.
And then finally for Dennis Moore, from what I researched, you basically spent a career on the defense side of the aisle, public defender's office, and now a defense attorney, criminal defense attorney in private practice. What is it from that perspective that you would bring to the position of judge, and how would you maybe check some of those very natural advocacy positions of a defense attorney to sit in a more neutral position of judge?
Well, one thing, as you said, I have been a criminal defense attorney for 18 years, and I'm proud of it. As being a criminal defense attorney, I have to be able to see both sides of the coin. In order to defend a person, I need to know what the prosecutor is trying to say that a person has done. That ability to do both, look at the case on both sides, allow me to have any partiality that must be needed. Just because you're a criminal defense attorney doesn't mean that you want criminals running in the street. Being a criminal defense attorney says that you're holding the state of Louisiana to its burden to prove whether or not a person is guilty of a crime before they take away a person's constitutional rights. That's what a criminal defense attorney does. As a judge, and being a judge, it's being impartial to make sure that the defense side and the prosecution side follow the law. Follow the law. The judge is actually controlling everything as far as making sure that the process is impartial, not fair. Everything says, and even if you look at it, they talk about impartiality. Because if I'm saying I'm fair, that means that I may have my definition of fair, but for the reason it says impartial. And I believe that as a defense attorney, and my history, not only in the criminal section, but also in civil area, it allows me to have that impartiality that is needed to be on this bench.
Good, thank you for indulging me those questions. And we're going to now just go ahead and do this in reverse order, like a fantasy football wraparound grab. Come back to you, Dennis Moore. We know that obviously the law is the law, the rules and policies of the court are set, but what issues in criminal court do you see as problematic that you could change as a judge?
There are several things, but I'll deal with three main ones. First, we need to modernize the system. It makes no sense that we have a system where attorneys, victims, defendants, their family cannot go online and actually look at a judge's docket online on a monthly basis. And also using the same technology to be able to see what happened when a person goes to court on that time. That's the first thing. We need to modernize the system. And that includes trying to go to a more paperless system. It's been done in this city and on the federal bench, and I know several other jurisdictions are trying to do it in the state. So that's the first thing we need to do. We need to come with impartiality. The second thing that we need to do to change the bench is that judges have to show that it's impartial, and we need to have it where everybody can see what's going on every day and every time as far as the system. As far gone that we do things in the back rooms or where people don't know what actually is going on. The third thing that we need to do is make sure that we hold both the defense bar and the prosecution bar to following the system or both the process that we have at the criminal bench. That's state law.
Same question for Mr. Guillory.
Thank you, Mr. Perlestein. One of the first things I think needs to be done is that we need to expand the court services that are currently available that I believe are being vastly underutilized. There are 12 sections of federal and adult court. They have wonderful programs that the court does have, such as reentry court. Sad to say that of the 12 sections, only 2 sections actually implement the reentry court. Additionally, you have drug court, which is another wonderful program, which helps non-violent first-time offenders with some sort of drug addiction or drug-related offenses participate in the drug court program, a drug rehabilitation program as part of their probation. Unfortunately, again, 12 sections of federal court, I believe about 4 or 5 of the judges actually have a drug court. You have a veterans court implemented by 1 judge. You have a mental health court implemented by 1 judge. Ladies and gentlemen, I can tell you that the majority of the young men and women in our city that are coming through the criminal justice system are coming through because they have some sort of drug addiction, or they grow up in an environment that is severely debilitated because of people around them with drug addictions. They have some sort of mental health issues, and they aren't receiving adequate assistance. The court can expand those services to make sure that they're providing the rehabilitative services necessary. Secondly, we have far too many people being incarcerated on bonds that are unreasonable. I think that some of the judges have the power to issue recognizance bonds in some cases when we're talking about non-violent first-time offenders, but they are afraid to do so because they're afraid of the public backlash that they would get immediately if they did take the opportunity to give someone a free bond and that person was arrested or re-arrested on another offense.
Judge Bonin.
Thank you. I don't disagree with anything both of these very fine ladies have said, but this would be my very first pledge if I were elected to judge a criminal district court, that all the proceedings in the section of court that I was presiding over would be open, on the record. There would be no sidebar conferences from which the public would be excluded at any time, except in those very limited circumstances in which the law requires confidentiality and privacy, but that all proceedings would be open and public as the Bill of Rights anticipated and demands that they be. That's number 1. Number 2, there's not going to be anything that's going to go on in Section D, if I were the judge, where somebody's going to be told, you have 3 minutes to decide whether you're going to take the plea to 30 years or take a chance of going to the penitentiary for the rest of your life. This is obscene behavior in courts, and it has to stop. The next thing that I would do is virtually immediately is invite into the courts, into the courtroom, people who actually know what they're talking about. The other day I had a beautiful listening session with 6 ex-offenders who, among them, had done 70 years and could actually explain what they're confronted with when they come home from the penitentiary and what we need to do to be supportive while supervising them in our system. I would bring them in and people who know what they're talking about. Thank you.
You can keep the microphone. Your number one segues nicely into this next question, which is act Tulane and Broad. We know it's a fairly common practice for defense attorneys and or prosecutors to talk with the judge in a private conversation without opposing counsel, whether it be in chambers or pre-trying a case, even though technically that would be an ethics violation. So in many instances, we also know that sometimes that access can be granted based on familiarity, friendship, campaign contributions. So the question is, for all three of you, what do you think of this practice and how would you respond to it if you were elected judge?
Well, the practice, you actually used it, I don't know, is it adverb or adjective technically? It ain't technically a violation of the Code of Ethics. It is a violation of the Code of Ethics for lawyers and judges to communicate with each other without the other side present. So that's a violation, and that's absolutely forbidden, and it ought to be punished or sanctioned when it happens. I, as a judge, would do exactly what I've done for the last 20 years as a judge. I wouldn't engage in it. This is what undermines confidence in our system. It needs to be done in public, and there's no reason for it not to be done in public. Because if it's not being done in public, there's something nefarious going on. That's it. So what I will do, I'll do the same thing I've done for 20 years as a judge. I will not entertain one side. We call it, the Latin word we use is ex parte. That means just one side there. Won't do it. And nobody should be doing it. And nobody, and no lawyer, prosecutor or defense lawyer is going to come up to me and try to do it.
First of all, as an attorney, I do not engage in ex parte communications with the judge. Now, I agree that ex parte communications with the judge, meaning a conversation with the judge without opposing counsel present, is improper. It's improper if you're discussing a case. You don't have to have another attorney present if you're telling somebody good morning or you're asking them how their mother doing if the mother's in the hospital. So let's be clear on that. All right, secondly, let me say this. I know that there's a question about accessibility about judge conferences and conferences that aren't available to the public. There is sometimes a need in criminal cases where conversations between both parties and the judge need to happen without the presence, without the jury, without the people in court and the public knowing what's going on. As I said, I've seen several attorneys and have practiced with it. Sometimes you have complicated cases where a defense attorney may be trying to work a deal with their client, and in exchange for that deal, their client may be willing to testify against another co-defendant or another person in another case. We don't want to engage on those type of conversations on the record, because later that day you'll be reading a news report from one of these fine journalists in here about how someone was murdered in Parish prison. So we do sometimes have conversations outside of the presence of the jury and the public as a safety precaution. Obviously, we don't put those things on record or just go back and say, oh, we were discussing the he's going to flip on everybody, and we don't want to get people killed. But what I can say is that there will be no improper conversations, ex parte conversations in my court. However, there is sometimes a need for communications to occur outside of the public.
Everyone has already said the same, but it is true that ex parte communication is unacceptable. We understand that it's unethical and it will not happen in my court. Instead of sitting there talking about the reason why this, that, and that, it's unacceptable. And it will not happen in my court. And I would hope that it wouldn't happen in the other guy's court, but if they came to my court and wanted to talk to me and have an ex parte communication after the election, I'll tell them, you can't talk to me. Bring the defense attorney and others come, and then if we need to put it on the record or have a conference at the court, we can also have the court reporter to come in and put it on record that way. And that's just silly if it's something that we're scared that someone may be in danger. So that's another way that we can deal with this. And then we do have a record of what is going on. But at no time will there be ex parte communication between me and the state or me and a defense attorney.
You give the microphone.